Annette, are we just sitting here waiting? Annette, Annette, can you hear me? Can you
Can you hear me?
can you hear me?
I can't hear you, Clinton.
Can you hear me now?
Not at all.
Can you hear me now? No. Dang it.
I see your mouth.
How about this? Can you hear me now? Can you hear me now? The frig.
Hold on, let me get my volumes up.
Hey, can you hear me now, Annette?
Thank you.
I don't think people can hear me. Check, check, check. It's showing that it's working. You can hear me
Good
now?
luck.
Yeah, okay.
We have a hearing. You're not there. What's on? Okay. Okay. Thank you so much for checking.
All right, Miss Molina, you there? She's in. She doesn't.
The other attorney, I think he just logged out.
Yeah, he just logged back.
Here they did.
They should all be there. And I've unlocked them so they can all unmute themselves. All right, so the virtual folks, if y'all want to take a second and check your audios. I've already checked it with Mr. Fletcher. He's good. Mr. Scholl, it says you need to connect your audio. There we go. I see you there.
Okay.
Perfect. I hear you. Great. You there?
Yes, sir.
Okay. Mr. Fletcher, we already checked yours, but I saw you got kicked out or logged back in. You still there?
He's muted.
Can you hear me now?
Yes, I can hear you.
Okay, perfect.
I had just muted it when I stepped off the bench. That was all. So,
Oh, gotcha.
Miss Molina, you there? You there, Miss Molina? Can you hear me okay, Miss Molina? Give me a thumbs up if you can hear me. I'm going to take that as a no. And then Ingram.
Yes, I can. I can. Can you guys hear me?
I can hear you great. I can't see you, but that's secondary to hearing you. So
I can. Camera.
So we're okay there. All right. All right. So Mr. Bennett.
Yes.
All right, I'm gonna call the calendar now. What I'm looking for is announcements for time and also whether or not you would like Miss Kathy to take down your hearing. So let's start with 19 SB 35, Ms. Gant and Mr. English. Good morning, Mr. Olson, welcome back.
Hey.
How long do you think y'all need?
Judge, this is my motion, and I represent the plaintiff in the case. My side probably will take 15 to 20 minutes. I do want to take them down.
Okay.
I'll name the tune in 5 minutes, and I'll share it to take down.
All right.
I'm gonna say 5 or less, Your Honor. Then we will also share in the takedown.
He's got 30 and takedown. All right, thanks. Y'all sit tight. And Ms. Gant, if you need to step back out, feel free.
Thank you so much, Ron.
All right, 20 SB 302, Bennett versus Dabbs. Ms. Molina is virtual, as well as Mr. Fletcher. Ms. Molina, can you hear me now?
Yeah, muted.
Your Honor, I can speak for the plaintiff. This is Charles Scholl. I'll be making the arguments today.
Okay. Okay. Well, if anybody has Ms. Molina's cell phone and needs to reach out to her, I mean, she might not be trying to reach out, so.
She's texting me. I'll text her and say.
All right. All right, Mr. Scholl, how long do y'all need?
Well, it's not my motion, Your Honor, so I would defer to opposing counsel.
All right, Ms. Fletcher.
Yes, Your Honor. I'll just need 15 minutes. And if for point of clarification, we're addressing both the motion for partial summary judgment and the motion to withdraw admissions, right?
That's my notes from our last calendar that I'm looking at.
Okay, perfect. 15 minutes or less, Your Honor.
You want to take it down?
Yes, please.
All right, Ms. Scholl.
Your Honor, probably 15 to 20 minutes total for both motions.
Okay. All right, now obviously if y'all have anything else that needs to be addressed, let me know.
Okay, and we'll share in the takedown as well.
Okay, perfect. All right, y'all can unmute yourselves. Thank you. Everybody's virtual.
An extra, the famous.
Do I have an extra? The counter.
Yeah.
Sorry. '22 SB 301 Benson versus Cole. Good morning, everyone.
Good morning, Your Honor.
All right, how long do y'all need?
Your Honor, we would need 15 to 20 minutes, and we would like it to be done.
Okay, Rosa?
This is Alan Hoffman for the plaintiff. I also need 20 minutes.
You share and take
Yeah,
it.
we'll share the takedown.
All right, thanks, Sean. All right, Smith versus 23 SV 49. Smith versus Airport Road. I think that's the one you said. They're done. They're off today's calendar. Okay, we'll mark that as off. All right, and then Mr. Van Mater just let us know that 23 SB 221 is off.
Oh, great, Judge. Adrian Britt, I'm the defense attorney on that one, and we had agreed to extend his time to respond to March because we had to cancel deposition. My client's citation hadn't been dealt with yet. So,
Okay.
great. May I be
Perfect.
excused?
Yes, I thought he had grabbed you and told it, he said everything was good, so,
Okay,
and I'll offer today.
thank you so much. May I be excused, Judge?
All right, everybody's just announced essentially at the same time, so I'm just gonna go by calendar order, so. All right, so we're gonna start with 19 SV 35 Ray versus Harbin. Y'all come on up, plaintiff to your left and defense to your right. Thank you. I had a notepad, I lost it, I'm gonna go get it. I'm only thinking about this one.
Next Friday.
Well, I'm back in. Yeah, for you and I. I know. I was under the impression it was she was resolved. And then I'm hearing. Yeah, so, we'll swear You and I will sort it out. Okay. All right, so, Ms. Kathy is here taking this down. This is 19 SV 35. Kenneth Ray Hooper versus Joseph Anthony Harbin and Caleb Scott Carroll. Mr. English is here for the plaintiff, and Ms. Gant and Mr. Olson are here for the defense. All right. Let me grab y'all's file, and then we'll be ready. Any housekeeping for the plaintiff before we jump in?
No, Judge.
Any housekeeping from either defense?
Okay.
So I'm gonna defer to Mr. Olson to argue first, just given the situation today.
Okay. That's fine.
We've agreed on that.
That sounds fine. All right. Well, Mr. English, whenever you're ready.
Thank you, Judge. Thank you, Judge.
Sure.
Yeah, I think it would be beneficial to the court for me to give a little bit of background on this.
Oh, yes. That's what this is all about, the background, how we got here, and what we're doing next. So please do.
All right, the genesis of this was a motor vehicle accident that occurred in 2017, February 2017 in Spalding County. My client was traveling north of town on 19, or whatever the highway is out there, like in 4-lane. And he was in a line of traffic. Accident occurred. We ended up suing 2 individuals, one of whom we've settled with, who was David's client. The other is an individual that Miss Gant represents. And what happened was we initiated a lawsuit, quickly settled with the defendant that David represents, and then we've been dealing with Ms. Gant. The other part of that is still open. There are 2, and this is the important part, there are 2 UIM carriers, one of whom is Hanover, the other is Foremost. My client had obviously 2 underinsured motorist policies. In February 2019 is when, well, I guess right either during January or February 2019, my client came to see me right on the eve of the statute of limitations expiring and wanted me to file a lawsuit. Asked me about it, and I threw something together and filed it. In the 2019 February, I filed a complaint against both the defendants. As the case rocked on after a while, I voluntarily dismissed without prejudice and refiled in Superior Court in March of 2020. I did not serve the UIM carriers until May 24th of 2022. They subsequently, as we started proceeding in the Superior Court, they subsequently presented motions to dismiss, arguing that the statute of limitations, as the UIM, was barred by the doctrine of latches, and that the statute had run. Therefore, I was kind of out of luck, and I filed a responsive brief to that. And we had an argument in front of Judge Coker. Two points I argued were, one was the combined argument of Ms. Gann, and there were a number of times at that time, but that was one posture. I was arguing against the statute of limitations and also against the latches theory. The other is I brought up an argument with respect to my right to withdraw. I'm sorry, you can't hear it? That's the first time I've ever been heard of.
None of our microphones are on. That's right.
All right. Anyway, I filed a notice to withdraw, which was converted into a motion to withdraw the dismissal, voluntary dismissal without prejudice. And that's what, after all said and done, that's what this hearing's about. Whether or not I should be allowed to do that. Obviously, my brother and sister over here think, no way, Jose. And I'm thinking, well, this is a novel concept, and what little expertise I have in researching the law, certainly not to the level of my esteemed colleagues over here, but I've not been able to find anything on point. Now, I found some that's kind of eating around the corn, but never anything right on point. And that's why I'm here. And I think it's, again, it's a novel concept. I think with regards to the law is what I'm depending on and what my eggs are in the basket of Code Section 91158B, which I have a copy of here for the attorneys. I'm sure they have it committed to memory.
I don't remember things that are written down.
And I've got a copy up here, so I'm good.
All right, well, in any event, the 91158B deals with something called a civil case disposition form. And it provides that if there's not been a case disposition form filed in a case, then the case is basically still open. So I would argue that the original state court action which I filed has never been properly dismissed because there has never been a case disposition form filed. And in my motion, which you have in front of you, I'm sure, there is an affidavit from the state court clerk where she searched the records and indeed found that there was no case disposition form filed. So her affidavit, along with the Code Section 91158B, forms the basis upon which I'm arguing that I've got the right of going forward on my motion and preventing on my motion to dismiss or withdraw my voluntary dismissal. As the court is aware, well aware, 91158B also says as part of the filing of the final judgment civil case disposition form, it doesn't give you any way. It says shall be filed. If the case is settled or dismissed. Now, my position is the case was going to be dismissed and was dismissed since I filed a voluntary dismissal without prejudice. Since there was not a case disposition form filed in that case, then my position would be that case is still open in your court. I know a lot's going on, and it's my fault for having the court here and having the Superior Court involved. When we argued this in front of Judge Coker, he ruled against me on the theory of statute of limitations and also latches. But we never got to this argument. For some reason, he felt like, and I think rightfully so, that the argument that I presented today was better done in your courtroom, since that's where the original dismissal without prejudice was filed, and that's where I filed the motion or notice of, which was converted to a motion. Judge, I've done a little research, as much as I could find on this, and there's a case out there called Accelerated Claims versus Howell and Johnson. I have copies of it for the court and copies for David and for this guy. You may have it. Well, I'm going to give you my highlighting. I'm sorry.
We can share.
No. You're sick. Don't want you sharing.
Nobody wants to share with me today.
Okay, for that one. That's all right.
Well, I think the pertinent part, as far as my position is concerned, with accelerated claims, and I apologize, Judge, I was going to give you a copy.
That's all right. You'll just give me the site. I'll pull it up.
Yeah. It is 358 Georgia Appeals, page 74.
Was that 358 Georgia Appeals?
74. It's a 2021 case.
I have it.
All right, and in that case, there are two things that I want to point to that I think support my claim. The first is that in that case, it was pointed out that a voluntary dismissal without prejudice is a matter of right and terminates the action. Terminates the action. It's over with. It's gone. It's as if it never occurred. It's final. It's a judgment. From my perspective, I know the other side is going to claim it's not a judgment, but in my position, my argument is a judgment. And secondarily, in accelerated claims, it goes to the effective dismissal is so complete that a suit dismissed without prejudice leaves the situation the same as if the suit had never been brought. And they cite Code Section 91141A in support of their reasoning on that. Judge, in trying to find something to, I guess, enlighten the court is further with my position. And this is not something I'm arguing right now as far as what the court's prepared to do. But I think there is something out there that would avail me of, depending on how you rule in this case, a motion to set aside. I know there's a code section 91160 that allows an individual to file a motion to set aside, allows them to file a motion to set aside a judgment of dismissal without prejudice, as long as it's done within 3 years from the entry of the judgment. So that's something that's out there potentially, but right now I am completely hanging my hat on the fact that the 91158 and also accelerated, the case of accelerated, in my opinion, gives me the right to proceed and provides me an avenue for withdrawing my motion to dismiss. Withdrawing the dismissal without prejudice. And if it does that, then we've got ongoing right now in Superior Court here, I've got the other half of the case with Ms. Gant's client that we haven't even talked settlement on that case. I've said, and I know Ms. Gant's overworked and things like that. It's just difficult to get a response back about where they are. If liability is an issue, I'd like to. But in any event, I would ask the court to consider this and allow me the opportunity to withdraw my motion. And then we could get on with the case as it should have been done to begin with. Unless you have any questions, Judge, I think it's fairly straightforward and narrow as to what I'm asking.
Yeah, I mean, it's a fascinating and novel question. I was not able to find much on it either. So, but no, I don't have any questions. I do understand it.
Okay.
It is fascinating and novel, and we're all a little bit in new territory here. So, all right.
Thank you so much.
Thank you. So, the floor is yours.
All right. So the way I see this is, if it wasn't in open court, I'd probably use a different phrase. This is an uh-oh motion because of the mistake with the UM carriers. And I get that. However, the basis of the why of how this motion came about should have no bearing on the decision on whether or not you have the power to set aside this voluntary dismissal without prejudice that occurred a long time ago now, on February 19th of 2020. So we're getting close to 4 years now, which I think we can all agree is outside the term of court that it was done in. So we're faced with sort of a double-edged sword on, is this a judgment or is it not? If it's a judgment, there would be finality to it. However, the case law that Mr. English has cited to accelerated claims tells you that this is in fact not a judgment because it makes the case act as if it never existed at all, which is not what a final judgment does. The final judgment actually confirms that this case did in fact exist, and this is the judgment of what we have decided for what went on in this case. So the voluntary dismissal that makes it seem like this case never existed in the first place is a completely different and separate animal than a judgment. Now, there's a couple of ideas here. Though 91158, the entry of the judgment that Mr. English has been citing to, specifically references a final judgment, which is what requires the civil case disposition form. So it almost, in my mind, seems impossible to argue that the voluntary dismissal without prejudice would be a final judgment, because had it been, and a disposition form filed, then the case would be over, as if there was a judgment, a settlement, or dismissed or otherwise disposed of. So it's as if we have to argue outside of both sides of our mouths to give credence to what Mr. English is arguing here. Now, on top of that, had this been a judgment, then the method for setting it aside is through 91160D, one of those three subparts under that subpart. Had the motion to set it aside been made within the term of court, the court would have some power to set it aside through some discretion if there was a meritorious reason. So not only are we all pretty certain we are not in the same term of court, this wouldn't be a meritorious reason when it's the that's the reason. Now the three subparts of 91160D that would give any power to set this aside if it was a judgment, and it's only if it's a judgment, which I don't believe that it is. However, if we want to agree with Mr. English on that for this particular part of the argument, we will. 91160D1, the grounds is if there's lack of jurisdiction. That's not the case here. 91160D3 is if there's a non-amendable defect on the face of the pleadings. That's not been argued. That doesn't exist. The face of the pleading is a voluntary dismissal without prejudice. It was filed. There's no non-amendable defect to it. 91160D2 is if there is fraud, accident, or mistake. Now, it would be only looking at whether there was fraud, accident, mistake in the filing of the voluntary dismissal without prejudice, not the reason for why we're coming back to try to get rid of it. That might be a mistake, but it's not the kind of mistake that would allow you to set this aside if it were considered a judgment. Because 91160D2 also says that the fraud, accident, or mistake has to be unmixed from the negligence or fault of the moving party. So if we're going to look at the reason of why the motion exists in the first place, it is through the ostensible fault of service on the UIM carrier. And of course, we've had some talks about service on UIM carriers and whether that's good law or not, but that's really not for your consideration today. Now, because it's not a judgment, none of that really applies. Because it's not a judgment, the disposition form isn't required. There are a few cases that do, in fact, suggest that a trial court may not order a complaint reinstated after the complaint has been voluntarily dismissed under subsection A of OCGA section 911-41. That's Matthews v. Riviera Equipment, 152 Georgia App 870, and Collier v. Evans.
Hold on, I'm still typing in the first one.
Sure.
152 Georgia App 870.
Yes, sir.
All right, I have that one pulled up, and give me a second.
Okay.
And then you do the next one. All right, I'm ready.
Collier v. Evans, it's 205 Georgia App 764.
I have both.
All right. Those cases do make it clear that a trial court can't reinstate a complaint that was dismissed without prejudice. The voluntary dismissal is a matter of right that does terminate the action, as we've been discussing. However, the Civil Practice Act doesn't make any provision for the reinstatement of an action after dismissal without prejudice, and that's distinguished from the recommencement of the lawsuit, which is what happened here. It was recommenced in the Superior Court. The court in Collier further stated that a trial court may not order a complaint reinstated after it has been voluntarily dismissed. I believe that you'll see in that case it cites to another one from probably even longer ago. It's Corrosion Control v. William Armstrong. The site, if you're ready for it,
Yes.
is 157 Georgia App 291.
I have it.
Okay. There's one other, just go ahead and give you the site. I'm not even going to mention too much about it. It's 110 Georgia App 393. That's from even longer ago. This is a long-standing principle that trial court doesn't have authority to reinstate the case once it's been voluntarily dismissed. And that's, of course, completely distinguished from the fact that the plaintiff in that scenario can reinstate it, which is exactly what happened. So I've gone over my 5 minutes that I told you I would stay under, but I'm going to steal her minutes. The end result here is if it's a judgment, it would have to be set aside through 91160D 1, 2, or 3, and there are no grounds for that. If it's not a judgment, a civil disposition form isn't required, and the trial court doesn't have authority to reinstate this case. Respectfully, we would request that you deny the motion.
All right, and that is the way I've been looking at it, just to, like, I get where we're both here, that this is judgment versus dismissal, all that. So I just want you to know, this is a fascinating question, and I just thought I'd tell you that I've enjoyed this fascinating question. So, all right, floor's yours if you'd like. So, do you have anything else you want to add, Mr. English?
Oh, I'm sorry, I didn't hear you, Judge.
No, that's all right. I mumbled. So,
No, anything I have to say would be repetitive. I just, you're very aware of where we're both coming from, so I've said what I need to say.
okay. All right. Anything else? Housekeeping from y'all? Okay. All right. Well, then, what I'm going to do as far as today goes is, oh, yes, Mr. Goal is, Mr. Hope says that once he and I talk, whichever way we go, he's comfortable with drafting the order. So, so I'm not going to get proposed orders from y'all. But I do expect to try to get a decision out quickly, so that you all can know which way you're going with what you have. So, all right. Do y'all need anything else from us?
Nope.
Okay. Again,
Judge, I really appreciate you accommodating us through all this.
well, like I said, sorry about the confusion at the last hearing, but again, this is a fascinating question, and I just think I just enjoy moments like this a lot because.
Well, this is kind of off the record. I was kind of.
Yeah, we go off record.
I was kind of
I'm gonna come back, we'll do with 20 SB 302, which is mostly everybody virtual, so, all right, so 5-minute break, everybody, and then we'll, do 20 SB 302.
Okay, thank you, Your Honor.
No problem. I'm gonna mute this, and y'all make sure you're muted while we're on break. All right, all my virtual folks can unmute themselves as needed. We're going to jump into 20 SV 302, Lewis Bennett versus Dabbs as administrator for James Evans et al. So, all right, so we have, we dealt with several things and then we kicked a couple over to here. So let's start with the defense. Let's make sure that what y'all are about to argue. Oh, and Miss Melina, did you get your audio? Can you hear me okay?
I can hear you. Can you hear me?
I hear you great now. So it all, you know, it always takes a minute. It's perfectly okay. So at least none of you are driving your cars and or smoking or whatever else our bonded arraignment calendar does. So anyway, so y'all are all good. Okay, so all right, any housekeeping from the defense before we jump in? I guess Mr. Fletcher.
I can't think of any housekeeping other than to just argue the two motions.
Yes, that's what I'm expecting you all to do. I just wanted to make certain that I wasn't missing something as we go. Because I already showed that I need to make several other decisions, and we've already dealt with those. We've just got these left, these two left.
Yeah, I mean, I guess the one, Your Honor, if I may, sorry to interrupt. The one housekeeping is a motion for attorney's fees was filed yesterday afternoon, or at least that's when it arrived in my inbox. I don't think it's ripe for today, but I think it bears on a lot of the arguments that are going to be made today. So if the court wants to issue an order from the bench on that sua sponte after hearing, I'm open to that. Otherwise, I look forward to taking advantage of the 30 days to respond. But again, the motion for attorney's fees bears on the issues raised in the two motions and whether they were frivolous. So I guess what I'm saying is we can somewhat argue it, but if the court wants to hear from me in 30 days by written word, I'm happy to do that.
No, that's fine. And I see it there, and it is on my radar, and I'll just figure that one out at the end of all this. So,
okay.
All right, let's go with the meat of what we got then. All right,
Sure.
Mr. Scholl, anything else before we jump in?
No, Your Honor.
Okay. All right. Well, Mr. Fletcher, I think you're going first, isn't that right?
Yes, Your Honor. I appreciate that. And first off, I am working from the home office this morning after waking up with a slight fever. So if you hear some dogs in the background, please indulge their outbursts until I can quiet them.
That is okay.
Yeah. And if it pleases the court, I'm happy to provide some background again, but after all the briefing, you might be already familiar. So let me know how much you would like.
How about just a good 60 seconds just to make certain that what you want me to pay attention to and what I'm paying attention to for context are the same.
Sure. First things first, we filed a motion for summary judgment at the end of the summer, a partial motion for summary judgment, which raised points related to whether the driver, Mr. Evans, was driving in the course and scope of his employment of my client, Transcontinental. We argued that he was on a detour. And then in response, plaintiff argued that we had admitted early on in the case that Mr. Evans was driving in the course and scope. Candidly, I'm the third attorney, second firm to be on this case, and I did not know that that admission had been made. And I'll just be upfront with the court. That is just an oversight. Immediately upon learning, along with our reply brief in support of our motion for partial summary judgment, I filed a response to plaintiff's motion to strike our argument and also our own motion to withdraw the admission. The base of such argument for asking the court to withdraw the admission is that there is a litany of cases, most recently the Supreme Court in the Bowen v. Savoy in 2020, which related to removing defaults for answers, the context of what the Supreme Court talked about was that cases should be decided on the merits. More specifically, there's the case law determining whether admission should be withdrawn is a two-point analysis. Would the withdrawal serve the presentation of the merits of the case? As the Georgia Supreme Court has often made clear that the facts and the merits of the case should be the core of the case, and it should take the trial courts should take great pains to limit what should be precluded from a case. They want what can go to the court and to a jury, if it gets that far, should be the facts and the merits. The second point that is the prong of withdrawing an admission is whether it would be prejudicial to the other side. Plaintiffs pointed that out, that they would be tremendously prejudiced if the withdrawal would be allowed to happen. The prime argument the plaintiffs have made is that this case has been pending for some time, agreed, and that defendant has had ample time to cure, and they didn't. And also, the plaintiffs may be prejudiced because there's potential evidence they could not obtain due to the delay. And also, they have chosen as a strategy not to pursue the evidence that he was in the course and scope because it was already admitted on the front end. Now, those are the arguments of plaintiffs for prejudice. In response to the prejudicial arguments, this issue was raised that he was not in the course and scope as far back as this summer. Any additional discovery they wanted to do, they could have done if they wanted to move the court, or they could have done informally because the parties have been working famously together to wrap up experts in treating doctors. Namely, I just took one of plaintiffs' treating doctors' depositions last week. So there's not this inability to do any further discovery on the issue. And I would also stipulate that what discovery there was has been produced in terms of what job Mr. Evans was supposed to be doing, where he was supposed to be. The policies and procedures have been discussed and vetted in depositions, and the receipts, fuel receipts indicating his general location at the time he was working, and the fact that the accident happened 50 miles away from the route in which Mr. Evans was traveling. So there's ample evidence if plaintiffs want to assert that he was not acting in the course and scope. So there's not this prejudice to this case. The issue of whether he was acting in the course and scope would serve the merits of the case. It explains the who, where, and why Mr. Evans was where he was at the time of the accident, why he was driving a bobtailed tractor without any load, and why he was so far south of his normal route, hauling sand from point A to point B around the Jackson, Georgia area, as opposed to the Perry area. So the case law, while broad, talks about how the court should allow in issues that affect the merits and facts and not rely solely upon either oversight or admissions. And obviously rules are there for reasons, but just as Bowen and Savoy set forth in 2020, the trial courts have very broad discretion to let in certain information that otherwise has been precluded because of either default or not a withdrawal of admissions. The arguments, and that's broadly the arguments defendants have made in our motion to withdraw the admission of whether Mr. Evans was in the course and scope of his employment. If the court would like to entertain response now from plaintiffs on that specific motion, or I dovetail it into why it supports our motion for partial summary judgment.
All right, let me see what Mr. Scholl would prefer. Mr. Scholl, would you prefer to respond in the individual pieces or in one larger pass?
I'd like to respond to each individual motion. If he's done laying
That,
out
that,
his arguments for this motion on the motion to withdraw admissions, I'd like to respond at this time, please.
okay, that'd be preferable to me as well, but I just want to make certain I got everybody's input before I make that call. So, okay, so Mr. Scholl, the floor is yours.
Yes, Your Honor. So just to give you an overview, a little bit of the facts. This is a case where, it was 2020, and Mr. Evans, the driver of the vehicle, checked into his job. He was he does deliveries of sand and gravel. He went to deliver sand and gravel, and he started very early in the morning. He ended up about 6:56 p.m. That's the last note they have of him checking in, doing a delivery or a drop off. And then at 1:30, he is pulled over in sort of a high-speed chase by several jurisdictions of police, fishtailing across 75, going back and forth, running drivers off the road. And the police managed to pull him over and get him. He's rushed to the hospital, incoherent, for a diabetic seizure, and that's what they determined.
AM, PM, 1:30.
PM.
PM. Okay, just
so 6 hours. 6 hours were essentially unaccounted for. Now, we filed suit in late 2020. And in early 2021, the defendants answered the interrogatories and admitted that at that time that Mr. Evans was transporting a load near Perry, Georgia at the time he was pulled over. That is interrogatory number 6. It's on page 273 of my brief. We sent interrogatories to Mr. Evans, and he responded that he had completed his hauls in the early afternoon. Sorry, this took place at 1:15. He was pulled over about 1:15. So early afternoon. And then the police report, when the police tracked him down, the police has this in the report that Evans told the police he was going to load his trailer in Atlanta. Okay, so that was the interrogatory responses we got. 9 months later, the defendant, Transcontinental, makes 5 admissions. We asked the questions in different ways about course and scope 5 times in request to admit. They admitted they were responsible for him, he was in the course and scope, etc. And then we go through all the discovery, through all the all the case management orders. You admonished us, I think, a year ago, and we needed to get things going, and that you were not going to sort of tolerate any any delays. And you gave an order to that effect, and discovery was closed. And then we get a summary judgment motion saying that, well, we should get a summary judgment because Transcontinental should get a summary judgment because there's no evidence that Mr. Evans was in the course and scope at the time of this incident. After all those admissions and all the discovery, they made a summary judgment motion. And then we responded with, obviously, the evidence that was in discovery to the summary judgment motion. And they responded by just saying, well, that doesn't count. And there is this 30B6 deposition that was done by the owner of the company that said he talked to Mr. Evans before he died, and Mr. Evans died soon during this discovery. You know that, and that he said he was going to lunch at the time. He was going to meet a friend in Perry, so he was down at lunch at the time. And then we asked Mr. Evans, the 30B6 witness in that deposition, well, did he do anything wrong? Is there anything that he did improper? Nope, didn't do anything wrong. Was he disciplined? Nope. Was he fired? Nope. Any problems? No, he was reinstated fully to his job, no issue. And based on that, they basically said that is all the evidence. They should get summary judgment based on that testimony, forgetting all the other testimony, and that their admission should be withdrawn after discovery. And so discovery's over. We filed the dispositive motions per your order, and then on the eve of the hearing for the dispositive motions, they then move for the withdrawal of the admissions that were 2 years old. Now, they say that, well, this was new evidence that we had, that there was this conversation where, Mr. Evans said that he was eating lunch at the time. That conversation was had the day of the accident. So this was not new information. This even preceded the litigation. It preceded all their interrogatory responses, all their admissions. And so they had this information from day one. This is not new information. They're just trying to, respectfully, Your Honor, they're just trying to change the facts of the case to fit a summary judgment motion. I think that's improper. Another thing they point out is these receipts for fuel. Their argument is that, well, we have these receipts for fuel that Mr. Evans had. He usually got fuel within a small radius or in the general area of the headquarters of Transcontinental. And they're saying, well, that proves that if he got gas there, then, he couldn't have been on a detour somewhere else. He has to stay around here. He has to stay within this radius. Well, this is an interstate carrier. They're registered as an interstate carrier. And the fact that they have an account with Pilot and that he got gas there and fueled up there is not dispositive that he was in the course and scope of his employment at the time he was pulled over in Perry. I mean, they're the ones that admitted, their own employee admitted he was going to load his trailer at the time he was pulled over, and they admitted in the interrogatories that he was working at the time. So we've got a situation, obviously, what it looks like, Your Honor, is that this man had a uncontrolled diabetes. He had a fit. He got gradually incoherent. That's evidence in the record by our expert, Dr. Isaacs. And he was just incoherent at the time. And that's what the evidence is. He was gone for 6 hours. Okay, so he didn't check in for 6 hours and was just sort of going around. There's no evidence that he was going to lunch with anybody. This is a self-serving hearsay statement by a dead person who we can't cross-examine. And we have no way to reopen discovery. I mean, we could ask to reopen discovery and look into all this stuff. But we're 2 years into this litigation, Your Honor. They made several admissions. And what we have is a hearsay statement that benefits Transcontinental. This is a statement that supposedly was made by Mr. Evans that just benefits Transcontinental 100%. And we can't verify this with who he was going to see with his by asking him. We can't look at his phone records. We can't look at any of that stuff. It's a hearsay statement by a dead person. And we have evidence in the record. The witnesses in the accident report were following him as he was weaving across the road, calling 911 in this multi-jurisdictional pursuit of this truck, this runaway truck. And we have a witness that said he was traveling behind Mr. Evans for 4 visits past the Perry exit. And he didn't stop, and then went 3 more exits beyond that. So if he was really going to lunch in Perry, why would he pass the exit and go on by it? So we have a hearsay statement, and what they're asking is to get summary judgment on course and scope, despite all the admissions that they've made. And, it's just inadmissible evidence. So, Your Honor, the legal standard for this, all due respect to counsel, but what he's saying is that the court should decide things on its merits, but the actual language for this legal standard is, would justice be subserved by the withdrawal of the admissions? And so that's a different standard. Subserved is sort of like, would it represent a manifest injustice to allow the defendant to withdraw these admissions that they've already made? I've cited 4 cases in our brief, Your Honor. And all of these cases are pretty much right on point. There is no explanation for why they originally made these admissions if it wasn't true, and they knew that at the time. But the cases basically have 4 points. If the admissions are supported, whether the admissions are supported by evidence in the record, and these are not. The admissions are supported by evidence in the record because we've talked about the interrogatories. the witness statements and everything else. Is the new evidence that they're claiming not supported and not admissible? And we say, yes, it's not supported and it's not admissible because this is a hearsay statement that doesn't fall with any exception. Is there any explanation for the delay or why the admissions were earlier made in the case? And if there's no explanation as far as the timing, why they weren't withdrawn sooner. So what the court is looking for is, say, a situation where maybe, someone was just mistaken. Maybe, so let's just do an example, and someone's, it's an auto accident, and someone pulls up to an intersection and they're hit, and, first they say, well, I had a red light. And then they later just say, no, wait, summary judgment, no, I had a green light. I'm just going to change my testimony and sort of manufacture a conflict in the evidence. The courts are very, very clear that that is not acceptable. That's the prophecy case. You can't just make one admission and then make another identical admission. Now, there is some leeway if there is a good reason. Say, this person, the person made the admission that the light was green later, but maybe they were hit and maybe their car got turned and there was a video camera from a nearby business that caught that. Well, that would prevent a manifest injustice because the reality is that person had the green light. He just thought he had the red light at first, but that's not the case here. The defendants offer no explanation for their admissions, no explanation for why they didn't withdraw them on a timely basis. The admissions are supported by all the facts in the case, and all there is this hearsay statement. And plaintiff would be greatly prejudiced because discovery's over. We can't go now and look at this man's records, Mr. Evans's records, phone records. We can't look at who he was talking to. We can't, go and discover what this 5-hour gap was, because why wouldn't we look at it? Because they admitted course and scope. So we'd have to reopen discovery, Your Honor, and go over all this stuff after all these extensions of the case management order and everything else. Your case management order in paragraphs 14 and 16 requires the parties to look at their discovery prior to the close of discovery. And it requires all substantive motions to be filed by September 1st. This motion to withdraw admissions was filed in November on the eve of the last hearing. It was beyond the deadline, Your Honor. And this is a substantive motion because it seeks to resurrect a dispositive issue. So this is the reason why we're, in part why we're asking for attorney's fees. We think this is just a unsupportable position. We don't think that the defendant, Transcontinental, should be allowed to just sort of change the evidence and present a hearsay statement that is just not supported by any ancillary evidence, eyewitness, or any other evidence. And we are just prevented from discovering this or looking into it. So we've wasted 4 to 6 months on this issue already. That's why we've asked for attorney's fees. And we would ask, in addition to responding to or denying their motion to withdraw the admissions, that the court grant our motion to strike, which we've laid out before, and which is sort of covered by what I've already said. They should not be able to provide this testimony, this hearsay testimony that contradicts what they've argued or what they've already admitted 5 times, and what's also been admitted in interrogatories. So that's what I have for now, Your Honor. And with the summary judgment, we also have some arguments on that.
Okay. All right. And obviously we covered, a lot of this last time, so I'm already familiar with these issues. So, all right, Mr. Fletcher, the floor goes back to you.
Your Honor, I will address briefly the issue of the declaration against interest of Mr. Evidence purportedly to Mr. Ogletree, the owner of Transcontinental. They're traveling way outside and just common sense, traveling way outside the normal path of your job to be 50 miles away for a random lunch does create a pecuniary interest to the extent there's the potential for being fired. Whether he was fired or not should not factor into that analysis. But also what plaintiff's counsel is overlooking is the other corroborating evidence that potentially supports the alleged hearsay statement based upon where the job location was, the daily job of Mr. Evans, which was to haul sand from one sand place to another in Jackson, Georgia, as well as the fuel receipts, as well as the location of the accident. And I will represent that the Mr. Evans was traveling northbound on I-75, heading back towards Jackson, not going to Perry southbound at the time of the accident, according to the accident report. But the res gestae of the rest of that additional evidence supports the alleged hearsay statement that he was going to lunch at the time of the accident. Was in Perry for lunch around the time of the accident. So the alleged hearsay statement should be allowed to stand as evidence that he may not be in the course and scope. Now, if the court is going, we would ask the court to, if it feels that there is an issue of fact related to course and scope, then the issue should go to the jury as to whether, in fact, Mr. Evans was or was not in the course and scope of his employment. Having said that, and if the court allows it, I'll now just go into the arguments, because the argument of the course and scope boils into the motion for partial summary judgment.
All right, proceed.
Okay. As this court is aware, summary judgment or partial summary judgment, and I apologize if I use full summary judgment and partial summary judgment for purposes of the motions today. It's actually partial, but just it rolls off the tongue easier when you say summary judgment. For purpose of the motion for partial summary judgment, yes, this issue of course and scope and the admissions, when it was filed, I was not aware of it. I was aware of the facts of the case based upon Ogletree, which led to the argument for the dismissal of vicarious liability, both regular common law vicarious liability and statutory vicarious liability, because we believe there was indisputable, clear and palpable evidence that he was not within the course and scope. If the court is inclined to accept or to grant the withdrawal of the admission and allow in the evidence, we still believe, based upon the alleged hearsay statement of Mr. Evidence, as well as the receipts for fuel, as well as the testimony about what his Mr. Evans' jobs roles, supports the argument that in this case he was not within the course and scope. The case law is pretty clear as to course and scope, and that it can be decided at summary judgment if it is clear and palpable. But otherwise, if a driver is not in the course and scope of their employment at the time, and the evidence of such can be both direct and circumstantial evidence, then it's within the court's powers to find that the driver was not in the course and scope, and Transcontinental is not therefore vicariously liable. This next part, as I go to the next sections, we've asked for plaintiff's claims to be dismissed and relates to the request for attorney's fees. The motion for partial summary judgment is valid and is not frivolous, because we have argued also in the motion for partial summary judgment that Transcontinental is not directly responsible either under a theory of negligent entrustment, supervision, training, etc., based upon the issue of Mr. Evans' uncontrolled diabetes. Under the Federal Motor Carrier Safety Standards, the company requires from its drivers a medical certificate, which they obtained of Mr. Evans in this case. The case law for negligent entrustment, supervision, training, etc., is that with respect to a medical condition or anything else that would demonstrate to the employer that the driver is incompetent to drive, the employer must have actual knowledge. As plaintiffs' response to our motion stated, they believe with their expert that we should have reasonably known, or the broad language of the Federal Motor Carrier Safety Standards say you should not let an incompetent driver drive. But the actual strict, explicit language of the statute is that the employer must get a medical certificate. It doesn't say that they must pull back the court curtain or look behind the determination or get into their driver's medical business. While the argument was not made in the briefing, I mean, there are HIPAA issues related to what the employer is entitled to know of its driver's medical history. That is the purpose of the medical examiner's role in the entire Federal Motor Carrier Safety Standards and regulations. The other purpose of the motion for partial summary judgment was to raise the issue that attorney's fees under 13(6) and 11 are not allowed for tort actions. Now, while it's a novel argument to be made, it is an argument to be made now in the post-Alston and Byrd Hatcher environment we now find ourselves. Well, prior to Alston and Byrd and Hatcher, under the apportionment statute, defense and plaintiffs' counsel kind of operated under the inference that you could still apportion if there was still, or apportion to a non-party if there was only one defendant. I mean, that is how generally attorneys were practicing at the time. But it took a savvy plaintiff's counsel to raise the issue to say, that's not what the statute explicitly says. And the Supreme Court agreed with them. And we all understand what came out of the Alston and Byrd Hatcher decision, and that no man's land of how to proceed with cases, and certain cases filing against a driver in one court, filing against the employer in another, or just only one defendant, so defense counsel couldn't do the apportionment. And this history of the Supreme Court saying, hey, I know you've done this way for years and years and years, but the statute is explicit, is not only reflected in the Alston and Byrd versus Hatcher case, but also the Benique versus Parker case that said the statute of limitations is even told for a minor traffic ticket for whatever moving violation. And the dicta from that was really resonated and is similar to Alston and Byrd is the court recognized that this new decision on the statute of limitations, that most attorneys had been assuming that it had to be a felony charge to toll. The Supreme Court said, sorry, I know this is going to be a significant impact on personal injury actions. That is the quote from the Benique versus Parker. So it is not a delay tactic for defendants to argue that attorney's fees, based upon the strict interpretation of the language itself of the statute of 13(6)(11), is not meant to apply to tort actions. It's in a section on contracts, talks about contracts, makes no mention of torts, and in strict statutory construction that the Supreme Court made clear in Alston and Byrd and Hatcher is apparent here. And now I know it's going to be novel for the court to, look at this in a different way than how every tort action has been filed in the last few decades. And as long as I've been practicing that, hey, I have a tort claim, I'm now also going to ask for my attorney's fees under 13(6)(11). That's how it's been done throughout the practice. The appeals court has held summary judgment or trial court judgments that have allowed attorney's fees. But in the Alston and Byrd v. Hatcher world we now live in, it is incumbent upon the trial courts and potentially appellate courts, if it gets up there, to review the actual statutory language. If the legislature, Georgia Assembly, had wanted tort claims to fall under 13(6)(11), under Alston and Bird and Hatcher, the assembly would have mentioned this is to apply to all actions, tort, contract, or otherwise. So now kind of folding into the motion for attorney's fees, the motion for partial summary judgment was not filed for purpose of delay. There are legal issues that need to be made related to that there's no issue of genuine material fact. Plaintiffs are going to argue, well, course and scope has already been established, but if the court finds that we should allow in the alleged hearsay statement, that's an issue of fact, and I'll stipulate to that issue of course and scope should go to the jury. Obviously, for purpose of the motion, we disagree. But the issues of negligent entrustment and the issue of attorney's fees are real issues that needed to be brought up and were timely brought up. And so we'd ask the court, one, allow the withdrawal of the admission related to course and scope. Two, determine that the facts indicate, both direct and circumstantial, that Mr. Evans was not acting in the course and scope. Three, Transcontinental is not vicariously liable either under common law or statutory, as plaintiffs would argue. Four, that Transcontinental did not have actual knowledge of uncontrolled diabetes or a history of it and relied upon the medical card. So therefore, without that actual knowledge, Transcontinental cannot be held liable. And then the issue of the attorney's fees. So even if the court is to deny all the arguments related to the actual liability of Transcontinental, there is a remaining issue of the attorney's fees and whether plaintiff's counsel is entitled to it. So it asks that the court grant our partial motion for summary judgment, deny plaintiff's motion for attorney's fees, or if the court wants me to brief it, I'm happy to, but I think the issues that have been discussed and the court can see in the briefing to date, I think the court can make a determination. And then lastly, which I said first, grant the motion for withdrawal of the admission. So if the court does not have any questions, plaintiffs welcome plaintiff's argument.
Okay. No, I do not have any questions, and no, I don't need you to brief the attorney's fees. I'm very comfortable factoring that in as I'm making my decision.
Okay.
Okay.
Well, if in light of that, Your Honor, if I may, if the court is inclined to grant their motion, I would welcome the opportunity to, preserve our argument with some briefing.
Okay. How about this? If I'm uncertain, then I'll have Mr. Hope send you an email asking for it.
Great. Okay. Thank you.
All right, Mr. Scholl.
Thank you, Your Honor. Your Honor, just want to briefly address the argument defense counsel made regarding the admission against interest argument. Mr. Evans was driving down, a commercial driver, driving down a major interstate, leaving a 50-mile trail of mayhem, but he had to be pulled over by Good Samaritans calling multi-jurisdictional police forces and law enforcement to pull him over. You're not allowed to drive a commercial vehicle as a type 1 diabetic. His career was over if he admitted that. And then he gets on the phone with his boss later that night and says, no, I'm okay. I was just going to lunch with a friend. So it's not an admission against his interest. It's an admission for his interest to sit here and say that, oh, I was just going to lunch with a friend. That's the most harmless, benign explanation, and I would say falsification he could come up with. So I just want to point that out to the court. Getting to the motion for summary judgment, Your Honor, the reason that we are making the motion for attorney's fees, Your Honor, is sort of made out by the fact that they're still asking for summary judgment, even after we pointed out and after they know that there's admissions that they made. And even if those are withdrawn, even if the court was to rule that those are withdrawn, There's still judicial admissions that are admissible as an admission against interest in the case. So that would defeat summary judgment right there. Not to mention there are other interrogatories which we've talked about and the police report. So to argue that there's no issue of material fact and go down that road even after we've talked about the admissions and as a matter of black letter law, they defeat a summary judgment because you've already made them, is sort of a frivolous position. And that's why we're asking for attorney's fees. It's just a non-defensible position to take in this case. I don't want to go on into it because I've talked about the evidence and I've cited the evidence in the record that Mr. Evans was in the course and scope of his employment of the admissions.
Time out, you're breaking up.
Okay.
Just take a deep breath, slow down, start over, but I didn't get the last 20 seconds.
Okay, sorry about that. All right, so let me try to think back. So, you know, our position is that even in the light most favorable to the non-moving party, you still have to acknowledge that there are these admissions that were made. And even if the court would true them, they still defeat a summary judgment. There's also this evidence, but nonetheless, defendant is still arguing for summary judgment based on this hearsay statement. And it's our position that that's a frivolous argument. So that's why we're asking for attorney's fees. And we're just asking for attorney's fees on this issue of course and scope because we've had to brief this and respond to it. We don't believe the other issues in the summary judgment have any merit either, and I'll go into those. But I just think the course and scope just rises to the level of being frivolous because, I mean, obviously there is ample evidence in the record. The record's replete with evidence that he was in the course and scope. And in fact, we could move for summary judgment. We just don't want to move for summary judgment because it's directly appealable and we don't want to further delay in the case. But regarding the issue of negligent entrustment, the law is clear. It's not, there isn't required to be actual knowledge when there is a legal duty to investigate someone's driving record. And with commercial carriers, there is a legal duty. And that's the case of Smith versus Tommy Roberts Trucking Company. It's black letter law. It's been the law for 30 years. We cited in our brief. Basically, the exercise of reasonable care, you have to, if there's a legal duty to, investigate the driver's background. And the defense, in this case, or Transcontinental, did not do that. They did not investigate his background. They did not look into his driving history. They did not look into his medical history. We have our expert whose testimony was not challenged, is still in the case. He gave a 40-page talking points, which we've submitted with his deposition in the record, where he cites all the times and all the regulations violated by the defendants. Defendant's own expert in this case admits they did not follow federal regs in respect to hiring Mr. Evans. There's also admissions number 64 to 78, where Transcontinental admits it did not comply with federal regulations in the application and hiring of Mr. Evans. So there is a duty to, you don't have to have actual knowledge, there's a duty to investigate, and the law, if the law imposes that duty, then you must comply with that. And that's the Smith versus Tommy Roberts case. Statutory employer, they talk about course and scope. With commercial vehicles, you don't have to be in the course and scope of your employment. You just have to be driving a commercial vehicle with permission. And if it's placarded, then you are, the trucking company is liable for what happens. And that's the cases, two cases I've cited in my brief, Your Honor. One of them is the AXA case, and the other is the Zagel case, I'm sorry. So those are cited in my brief, very, very clear. And then with respect to attorney's fees, Your Honor, I'm not even going to go into we've done in our brief, I'm not going to go into the sort of constitutional arguments versus contract versus tort. 120 years, Your Honor, there's been 13611 attorney's fees in tort. I'm doing a trial next month and I've got 13611 damages, and we're going to argue that in a tort case. This is sort of a Hail Mary to say that the court should make basically a constitutional argument that contradicts established precedent by the appeals court now in this case. And I just encourage the court, or hope the court won't pursue that adventure. I've cited 3 cases, Your Honor: the Royalston case, the Aldridge case, and the Smith case that I've alluded to before. They're all on point that violations of the federal regs, the motor carrier regs, are sufficient for bad faith under 13611. So that prong, bad faith, is there. And then untrouble or undue expense, you're going to cite to, what we've talked about with respect to attorney's fees in this case, and the delays that we've had to deal with responding to motions that are not substantive, or not legally substantive or factually substantive. So we think there's ample evidence on the record that there's been delays in this case by arguments and motions that are not appropriate or justified under the record and under the law. So anyway, that's our position, Judge. We ask the court to deny all the motions for summary judgment filed by defense. We don't think we don't think there's any merit to really any of the arguments that they've made in those motions. And then again, we ask the court to grant our motion to strike and deny the defense's motion to withdraw their admissions. Thank you.
Thank you. All right, Mr. Fletcher, anything else?
Yes, Your Honor. There was a couple statements. I have actually 4 statements that the plaintiff's counsel made that I think need to be addressed, and I'll go in reverse. Related to the attorney's fees of OCGA 13611, understood. Plaintiff's counsel have for decades and will continue until told otherwise asked for attorney's fees related to tort actions. This is not a Hail Mary, just random asking the courts now to revisit. This is an actual legitimate argument made in light of the Supreme Court's decision in Alston and Byrd versus Hatcher, where they made it very clear. I don't care what y'all have done in the past. This is what the statute actually says. And using the basic statutory construction principles, it made no comment in the apportionment statute about being able to apportion to non-parties if there's just one defendant. So Alston and Byrd, the Supreme Court was very clear in that they were using statutory construction and the General Assembly's intent to say that the statute doesn't say what everybody assumes it to say. And that's the case here. It's not a constitutional argument that defendants are making for the inapplicability of OCGA 13611. Defendants are making an argument that the clear language of the statute, where it's located in the code, and the General Assembly's intent is that it's not meant to apply to tort cases in light of the Alston and Byrd and Hatcher decision. This is just a statutory interpretation relying upon the court's direction in how statutes are to be interpreted. And the argument that this is how we've done it for decades or centuries does not fly anymore in light of Alston and Byrd and that Beneke decision I just told you. Now, with respect to the Smith versus Tommy Roberts trucking case about a duty to explore the background, that's the background of whether the driver has a CDL, has the appropriate training, has the MVRs, has he been involved in any accident. Smith versus Tommy Roberts makes no comment about the duty of an employer to go and stick their nose in very personal and private issues related to health. That is the purpose for the medical certificate requirement under the federal regulations. The employer is not a healthcare provider. The employer is not a doctor. The employer, in none of these cases cited by plaintiffs, say that the employer must grill their employee about their medical background and then determine if that medical background makes them competent. That is the role of the medical examiner. And in this case, Mr. Evidence had his medical certificate. If he shouldn't have, that is an accusation to be made against the medical examiner. Now, Smith and those cases that talk about a reasonable duty to explore the background of a driver has nothing to do with medical. It has solely to do with their capacity to drive a vehicle based upon their training, how many accidents they've had in the past, and whether they've had any citations or otherwise. Now, this statement that the reason Mr. Evans did not want to tell anybody and made a hearsay statement from his hospital bed was he knew he had type 1 diabetes, and if he admitted that, he wouldn't be driving. That's not the law. The law under the federal regulations is you can drive a tractor as long as you're taking insulin to treat your diabetes. The law was changed and the regulations put in place as recently as 2018, 2019, allowing diabetic drivers to drive as long as it is controlled. Now, again, if he did not control his diabetes, that's either Mr. Evans' fault or it's the medical examiner for not looking into the diabetes issue, confirming the diabetes issue, and then determining if he could grant a medical certificate to drive. And lastly, and I know this is for purposes of argument, and Mr. Scholl has done a fabulous job to, if you can't argue the facts or you can't argue the law, to just bang your hands on the table. There's no evidence that this was a 50-mile chase of mayhem. The only contact of alleged mayhem was where the accident actually happened, where it's alleged that he either hit Mr. Bennett or he at least weaved to drive Mr. Bennett into the guardrail. So I would just have the court recognize that, just treat that statement as it is, which is hyperbole. But again, I would ask the court to grant defendant's motion for partial summary judgment by allowing defendants to withdraw that admission and deny plaintiff's motion for attorney's fees under 91514. I think I cited that statute right. And if the court does not have any further questions, I've got no further argument.
All right, so let me do a little housekeeping on my end. I show that between the last hearing, which looks like back on November 3rd, and this hearing, it appears that I now have 8 outstanding orders that y'all are waiting on from me. It looks like I have, starting with the plaintiffs, it looks like I have a 702 motion for Bailey, a 702 motion for Frankel, and a 702 motion for Stern. I then have the plaintiff's motion strike that we dealt with today, and then the plaintiff's attorney's fees, which we kind of dealt with today. I just put it on the table, but we haven't really dug super deep into that. That's what I show that the plaintiff is waiting for me to do. Is that correct, Mr. Scholl or Ms. Molina?
I believe it is, Your Honor.
Okay.
I believe that's correct.
All right, if y'all realize I'm missing something, let me know. Moving on to the defense. I show that the defense needs me to rule on the defendant's motion for partial summary judgment, which we just argued. I show that you're waiting on a ruling from me on the 702 motion for Isaac, which we argued last time. And then, obviously, the related motion of the motion to withdraw the admissions, which is kind of a cross motion with plaintiff's motion strike. But I show 3 orders that the defense needs from me to settle all the motions out from y'all's end. Is that everything?
Sounds about right, Your Honor.
Okay, that's my working list that I've created as we've done these 2 hearings. So, okay, Do y'all need anything else before I go talk to Mr. Hope, just for a second, before I wrap this one up?
No, Your Honor.
Okay, y'all sit tight. I'll be right back. Okay, back to more procedural questions, y'all. I think y'all have already given us proposed orders on at least the 702 motions. Am I mixing y'all up with another case, or have y'all sent us in the proposed on the 702? Yes, okay,
Correct, Your Honor.
So that means I have 1, 2, 3. So that means I would need additional proposed orders on plaintiff's motion to strike, plaintiff's motion for attorney's fees, and then the defense partial motion for summary judgment, and the defense motion to withdraw admission. So four more orders from each of you. Is that correct?
Yes, Your Honor, that sounds about right. But with respect to the motion for attorney's fees, if you're leaning one way, particularly negatively against defendants, I welcome the opportunity to brief it first before I do a draft order.
Okay, well, why don't you just do both together? So when you draft your response motion, just send a proposed order with it.
Okay.
I'm going to do 30 days, so that would fall in within your 30 days to normally respond.
Yes.
Does that work, Mr. Fletcher? I'm not trying to back you into a corner.
No, I mean, you're not backing me into a corner. I was saying it'd be easier to do an order if the court's inclined to decide one way at this point, based on what it's heard. But
you're going to give me an order telling me what you want me to do. So, I mean, obviously your order, I assume your order would not tell me to grant the attorney's fees. So, so I would say you should probably draft me an order denying the attorney's fees, because I'm pretty sure Mr. Scholl's going to send me one that says I should grant them.
That is true. I was just blissfully hoping we'd get an order from the bench on the attorney's fees, saving everybody time.
Yeah, I know, but if I didn't have 8 motions outstanding, you probably would get an order from me on that from the bench. But I just want to get those and go through all 8 one more time before I issue my decision. So again, y'all have a lot of moving parts. Y'all have a complicated case. Y'all are all great attorneys. I should say that again. It is always a pleasure to have good attorneys here, even if you're virtual. You all have great internet connections. You've almost broken up almost little, if not at all, which is a nice change of pace from what we normally deal with. So, but y'all did a great job. You've well briefed everything. And again, I think I said this last time, and if I didn't, I should have. It's always nice to have such high quality attorneys come to our courtroom and frankly make me a better judge. So thank you all for that.
Thank you.
Thank you, Judge.
All right, so that's it. So Mr. Fletcher, for your team, I just need one more brief, which is on the attorney's fees. And then when you send that in, submit a proposed order on that. And once I get all of those, you will get my answer quickly, because I'm going to grab all 8, file them all contemporaneously, and that way you've got everything there in one pass.
All right. Thank you very much.
Thank you.
All right. So we'll get all those. Let's just 30 days from now, whatever that is.
Okay.
Do y'all need anything else?
No, Your Honor.
Yeah, this is a leap month with 29 days, just so everybody knows.
That's exactly right. I totally forgot about that.
Yeah, so I was just stating that, so we're all on the same page, because I now need to do the math in my head with the 29th day. So,
all right, so let's just have them. Y'all just have them turned in before the end of the day on March 4th. That's a Monday.
Okay.
So we'll just go ahead and set that. It's easier to give you all a date certain. So If y'all will get all the orders in by March 4th, end of the day, that'd be great. We'll look at them Tuesday morning, get y'all out decisions.
Okay.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Again, Ms. Ingram, I didn't hear from you, but good morning and welcome to the case.
Good morning, Judge.
Do it. Okay, was Miss Standard here for y'all's case, or was that a different case?
Probably another case, Your Honor.
That's fine. We just didn't get a chance to talk to her. Okay, that's it. Thanks, y'all.
Thank you, Your Honor.
Thank you.
Appreciate it.
Bye-bye.
All right.
Bye-bye.
All right, so let's come back on record. So this is our third and final case of the morning, 22 SB 301. Since y'all want to take down, let's just go ahead and get everybody's names on the record. So starting up here with the plaintiff.
Good morning, Your Honor. My name's Alan Hoffman, ALLEN HOFFMAN. I'm counsel for the plaintiff, Ava Benson.
Okay.
Good morning, Your Honor. Molly Beth Amick, counsel for the defendant, and my co-counsel is Kelly Shartash.
Okay. And Ms. Amy, if you'll spell your last name just to have a.
Yes, AMICK.
Okay. And if you'll spell your last name.
Yes, Your Honor. CHARTASH. Thank you.
All right, got it. So, all right, that's a new thing that I've started for Ms. Leach because I move fast and sometimes I don't make good records, and I have the record coach right here helping me do that better. So, okay, well then let's jump in. So, any housekeeping from the plaintiff before we step into everything on this one?
No, Your Honor.
Any housekeeping from the defense?
No, Your Honor.
All right, so let me pull this up. Submission to dismiss. Is that all we're arguing, or is there anything else?
Just the motion to dismiss, Your Honor.
All right, what's yours?
Thank you. As I'm sure you all remember, we were here 2 weeks ago on this motion, and Your Honor, I briefed our argument at that time. I'm happy to go through and just give a brief summary if that's helpful to the court.
That would be very helpful because
Okay.
I'm trying to get the other cases back patterns out of my head.
Understood. Also, when we were here last, you mentioned perhaps needing a cork board and some yarn to keep track of the facts in this case. So we went to the trouble of preparing a demonstrative that I'd like to offer,
Very great.
if that's all right.
And we actually have a, hold on, no sense in wasting goodies.
Yeah, I got it, Judge.
You got it?
I think it's sitting right there.
There's enough, it's behind my door inside chambers. There's two of them.
That was my exercise for this morning.
Yeah, so I'm gonna let you off the hook there. Judge Essery had 3 or 4 easels for all kinds of stuff, but he's gonna get you one here in just a second. So,
Thank you.
all right, you may continue.
Thank you. So, we're here on our motion.
He said that, I've got it. We'll let y'all continue.
Okay.
You're right, I was just moving fast.
The underlying accident happened on October 12th of 2020, and Ms. Benson filed her first complaint in 2021. There were no attempts of service for a period of 161 days. And there is a disputed attempt that occurred on March 31st of 2022, and I won't belabor that, but the initial case was dismissed by the court in July of 2022 for failure to perfect service. Ms. Benson then filed the current lawsuit on October 10th of 2022, which was 2 days before the statute of limitation expired. There was an attempt on October 12th to serve a Brandon Virgil Cole. I'll note the defendant in this case is Brandon Lee Cole, who you will hear from today. And with respect to the service attempts, they're delineated in the recent affidavits of due diligence for 2 individuals, one Brandon Virgil Cole and one Brandon Lee Cole. So you'll see on our exhibit here 2 different colors. The orange represents Brandon Virgil Cole, and the blue represents Brandon Lee Cole, who again is the defendant in this case. After the initial attempt was non-est on October 12th, 30 days passes before any attempt is made on the actual defendant, Brandon Lee Cole. In December of 2022, the plaintiff recognized the option of filing a motion for service by publication, and there's a record of that being raised within the exhibits filed with plaintiff's response to our motion. Then no service attempts until January 4th of 2023, and you'll see there that was again on Brandon Virgil Cole. Another 54 days passes until an attempt in March on Brandon Virgil Cole. 9 days, we have an attempt on Brandon Lee Cole. 44 days passes before another attempt on Brandon Lee Cole. And then another 24 days passes. After that 24-day period, in May of 2023, plaintiff's process server, Steve Basham, was appointed by the court and made several attempts between May 20th and June of 2023 on Brandon Virgil Cole. He made an attempt on Brandon Lee Cole on June 17th of 2023, and then attempts on both Brandon Coles on June 25th of 2023. Between June 25th and August 30th, which is the date of purported service according to plaintiff, no additional attempts on either individual were made. And so what this represents to us is a timeline demonstrating the plaintiff's failure to meet her burden of due diligence. And I'll note that that burden was heightened after we filed our motion to dismiss on August the 2nd of 2023, raising service as an issue. Briefly, the law on this issue is well settled that merely filing a complaint doesn't commence a lawsuit unless the defendant is served within a reasonable time period, and the burden of locating and serving the defendant is on the plaintiff. If service cannot be obtained within 5 days after filing and before the statute of limitations expires, then the court should look at whether the plaintiff is in any way guilty of laches, such that the statute of limitation isn't told by the filing of the complaint. Numerous attempts at service still may be insufficient to show that that diligence was performed by the plaintiff, especially when there are attempts that are punctuated by unexplained lapses in time. And we've cited case law in our briefs, Your Honor, that even when service is actually perfected 5 months after the statute of limitations has expired, the court has affirmed summary judgment on this issue in favor of dismissal. And if conforming service is not established, which it has not been in this case, then the doctrine of laches prevents the statute of limitation from tolling. And that is our argument, which again we have briefed in our initial brief and reply. At this time, unless the court has any questions, I would like to call my client Brandon Cole.
All right, let me see if the plaintiff wants to make an opening. Do you want to make an opening or anything?
I'm gonna wait, hear what he has to say.
That's fine, just want to make certain that if you wanted to speak, you could. All right, if you'll come on up here and Piper's gonna flip on the mic there for you. All right, you may swear your witness.
Thank you. Could you please raise your right hand? Do you swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Could you please state your full name?
Brandon Lee Cole,
What is your date of birth, Mr. Cole?
10/25/86.
Where do you reside currently?
Currently I'm homeless.
How long have you been homeless?
Going on about 3 months, roughly, 3 or 4 months.
Do you have an address where you're able to receive mail?
Yes, ma'am.
What would that address be?
2564 Jackson Road, Griffin, Georgia.
Are there any other addresses where you receive mail?
Yes, ma'am.
What
My
would-
job would be 175 Lake Mirror Road, Forestburg, Georgia.
And where are you employed?
A company called Terra Plastics.
How long have you worked for Terra Plastics?
Almost 8 years.
So you were working there when this subject accident happened in 2020?
Yes, ma'am.
And Did you mention, I'm sorry, another address, or was work in 2564 the two where you received mail?
I do get my other one. It would be 1244 LaBelle Street, Jonesboro, Georgia.
Okay. And I'll ask you a couple of questions about those addresses in just a moment. But before we get to that, do you have a driver's license?
Yes, ma'am.
Is it issued by the state of Georgia?
Yes, ma'am.
What address is listed on your driver's license?
2564 Jackson Road, Griffin, Georgia.
What's your driver's license number? Do you know it?
No, sir. Okay.
Do you have your license?
Yes, sir.
May I have it?
Yes, sir.
All right, you may continue.
Thank you. You mentioned you've been working at Terra Plastics for 8 years, correct?
Almost 8 years, yes, ma'am.
Do you work full-time or part-time?
Full-time.
And is that, do you go into the same location every day for
Yes,
employment?
ma'am.
And you said that was in Forest Park, correct?
Yes, ma'am.
Okay. Are you registered to vote?
No, ma'am.
Do you own a vehicle?
Yes, ma'am.
What type of vehicle?
2000 Chevy Suburban 2500.
Is that registered in the state of Georgia?
Yes, ma'am.
Do you recall what address you used when you registered the vehicle?
2564 Jackson Road, Griffin, Georgia.
And that's in Spalding County?
Yes, ma'am.
Alright. Since 2020, have you ever resided outside the state of Georgia?
No, ma'am.
I have a few questions about the addresses that you listed. Let's start with 2564 Jackson Road. Do you currently reside at that address?
At the moment, no, ma'am.
When is the last time that you resided there? And by resided, I mean stayed consistently on a regular basis.
Probably going on to a year now.
Okay. If you don't reside there, why do you still list that as an address?
Because I don't have a permanent address.
Do you still receive mail at that address?
Yes, ma'am.
How do you know when you receive mail there?
A good friend of mine owns the property, and he lets me know I have mail.
And what's his name?
Jeffrey Atkins, ADKINS.
And the other address you mentioned, was that 1244 LaBelle Street?
Yes, ma'am.
What city is that in?
Jonesboro.
Is that also in Spalding County?
No, ma'am. It's Clayton.
Do you currently reside at that address?
No, ma'am.
Have you ever resided at that address?
Yes, ma'am.
When's the last time you lived there?
I was 18 years old, so I'm 37.
Okay. Do you know who currently resides at that address?
Yes, ma'am.
Who is that?
Ronald Allenbaugh and Susan Allenbaugh.
Do you have any relation to Susan and Ronald Allenbaugh?
Yes, ma'am.
What's that relation?
Ronald Allenbaugh is my uncle, and Susan Allenbaugh is my grandmother.
How do you know if you receive mail at that address?
My uncle will let me know.
Then what about your work address? How do you know if you receive mail at that address?
My HR lets me know.
Other than those three addresses, is there anywhere else that you receive mail?
No, ma'am. Besides the email.
Do you know anyone by the name of Brandon Virgil Cole?
No, ma'am.
Do you know anyone by the name of Bruce Evans?
No, ma'am.
Are you familiar with a residence located at 614 Cameron Landing Drive in Stockbridge?
No, ma'am.
Are you familiar with a residence located at 10295 Briar Bay Drive in Jonesboro? Are you familiar with a residence located at 338 Hammond Drive in Griffin?
Yes, ma'am.
How are you familiar with that residence?
That was my residence for a couple of years.
Do you recall the last time that you lived there?
In 2014.
Since 2020, have you resided at that address?
No, ma'am.
Do you know who currently resides at that address?
No, ma'am.
Are you familiar with any residences on Big Sky Drive?
Yes, ma'am.
What residence are you familiar with on that road?
10968.
How are you familiar with 10968 Big Sky Drive?
My sister lived there.
Have you ever resided at that residence?
No, ma'am.
Are you familiar with a residence located at 560 Lakewood Road in Griffin, Georgia?
No, ma'am.
Are you familiar with a residence located at 615 Northside Drive, apartment H5?
No, ma'am.
What about 615 Northside Drive, apartment 29D?
No, ma'am.
Do you have any aunts that reside in Spalding County?
No, ma'am.
Do you have any brothers that reside in Spalding County?
No, ma'am.
And have you been served with a copy of the summons and complaint in this lawsuit?
No, ma'am.
I don't have any further questions.
All right, Cross.
Good morning, Mr. Cole.
Good morning.
You said you're homeless right now?
Yes, ma'am. Yes, sir. Apologies.
What does that mean on a cold night like last night?
I have overalls.
Overalls, you said?
Yes, insulated overalls.
So you're sleeping on the street?
No, sir.
Where are you sleeping then?
In my truck.
So you're living in your truck?
For the moment, yes.
Where did you stay last night?
Last night I stayed in Swanee.
Is that the city north of Atlanta?
Yes.
Why were you up in Swanee?
I met a girl.
How long have you been living with that girl?
I don't live with her.
What's her name?
Lisa Carsdale.
How do you spell that last name?
I'm not sure.
Can you read?
A little bit.
How long have you been in Swanee before today?
Wasn't there today. I was there last night.
Were you there yesterday?
Oh, yeah, because I was there last night.
And were you there the day before that?
No.
So you were only there yesterday?
Last night.
So where else have you been recently?
Work.
So what are your hours at work?
8 to 8.
Are you telling me that you sleep at your employment?
In my vehicle.
So you sleep in a parking lot at your employment?
Yeah.
And that is Terra Plastics, you said?
Yep.
Terra Plastics?
No, sir.
How do you spell it?
Tara.
And what do you do there?
I'm a lead man.
What does that mean?
I have gentlemen that work under me, and I make sure that what is going out is production and that it's quality.
What kind of mail do you get to your employment?
Insurance for my medical.
So HR doesn't forward that to another address?
No.
Did you ask for that specifically?
No, she knows my situation, so they had to sit there.
Well, as I understood your situation, you're getting your mail delivered to several places simultaneously, isn't that right?
No, I'm not. The junk mail is going to the 1244. That's one thing that's been there.
So junk mail is going to 1244 LaBelle Street, is that what you're saying?
I'm guessing that's what it is, because it's usually nothing that's in matter, because everything that is in matter comes to my emails.
What about your vehicle registration?
I get emails too as well, with a letter that goes to 2564, where I was living.
So how do you get the little sticker every year you're supposed to put on your license plate?
You go to the tag office and get it.
So that's what you do every year? You go to the tag office?
Yeah, to register my vehicle, yeah.
I thought you mentioned earlier that some mail does come to the 2564 Jackson Road address, such as your driver's license, isn't that right?
I just said that.
And that mail is then forwarded to you by the owner of that residence?
Or I don't know what you mean by forward, but it is handed to me.
So you go pick it up personally?
Yes.
How often do you do that?
whenever he calls.
When was the last time you called?
Takes me maybe 3 days ago. But it wasn't about mail, it was just checking on me.
So you mentioned that you were on this, you've been homeless for about 3 months, is that right?
Yep.
I don't want you to speculate. Has it been 3 months? I feel like you remember how long you haven't had a
No, I
home.
don't know the exact date.
Was it still fall?
It's been about 3 months. I mean, I couldn't tell you exactly like 120 days or nothing like that. No, sir, I can't do that.
Were you homeless on Christmas?
Yes.
Were you homeless on Thanksgiving?
Yes.
Were you homeless on Halloween?
It was right around that area or whatever.
So where were you living prior to becoming homeless around Halloween of last year?
Between, really here and there, honestly, because it wasn't no consistent place because I was just trying to figure stuff out.
But none of the addresses your attorney mentioned to you were the addresses you were staying at during that time period?
From when?
From October until now?
To October 23?
Yeah.
So not, no.
And then prior to that, you were just staying at various different places?
No, not various, no.
Which places were you staying at?
I had an RV, would stay between 2560 Road. That's where one of the places where I would stay would there, but it wasn't consistent. So, as I said, consistent would be somewhere long term. You know what you just asked?
I don't know. I guess I'll object to the responsiveness, the answer to that question. I'm not sure I understood what he said.
That's all right. Take a deep breath and slow down.
Understood.
It's okay. Deep breath, deep breath, deep breath.
Okay.
Slow down your answers just a little bit because I'm having just a little bit of trouble tracking your answers. So I'm going to have you ask the question again.
Sure.
Now that he's going to slow down a little bit because I missed the last couple of things he said when I was listening. That's okay. That's what I'm saying. Just deep breath. Everybody wants to get the right information on the table. All right, go ahead. Ask it again.
So what I asked you was, like, prior to being homeless, I think you mentioned that you were staying at some various places, and I was trying to understand what places those were. What did you mean by you were staying at various places?
I would get a hotel room or stuff like that.
So you weren't staying with family and friends?
No.
You mentioned you had an RV.
Yes.
Is that registered in the state of Georgia?
Yes.
Where is it registered to?
2564 Jackson Road, Griffin, Georgia.
And you mentioned that at 1244 LaBelle Street in Jonesboro, that's where your uncle and grandmother live, is that
Yes.
right? And the last time you lived there was when you were 18 years old?
Yes.
And since then, you didn't stay there for any reasons, for any period of time?
Just for maybe a holiday or something.
Did you mention that the owner who hands you your mail at 2564 Jackson Road, that was a Mr. Akins, right?
Atkins. Yes, sir.
Atkins. And he resides next door to that?
Yes.
So in June of 2023, that's not where you lived?
June of 2023? No.
Where did you live at that point?
High Falls, RV park.
Have you been in jail this year?
No, sir.
You have a criminal record though, don't you?
Yes, sir.
So on December 30th of 2023 of this year, you were not cited for driving DUI in less or a less safe manner and leaving the scene too fast?
No, sir. In what county? I'm only asking because I've got the docket in front of me. Or city, I guess.
Yeah, my document here says that it's 2023 CR 09722 MG in state court with Honorable M. Garrett presiding.
That's Clayton County.
It's Clayton County.
That's Chief Judge Garrett.
So is that not the right Brandon Lee Cole?
That's right, Brandon Lee Cole, but that wasn't the date. That is not when it happened.
When did it happen?
February 5th of 2023.
So have you been in court for that citation?
No, sir. Still waiting on a court date.
Have you been arraigned?
Don't know what that means, sir.
Have you made a plea that you're guilty or not guilty?
No, sir, I haven't been in court yet.
Objection, Your Honor, to improper impeachment of the witness.
There's no jury, I'll allow it, but it is improper, so just keep going. I'll sort it out.
Have you been incarcerated at all this year?
No, sir.
Is there anybody else who could offer any testimony that you know of that would support what you're saying, that you've been homeless for the past 3 months and you were living in an RV prior to that?
I don't even know anybody would even come in the courtroom, to be honest with you.
Did you ask anybody to?
Had no reason to.
You don't think it would help your testimony to have somebody else support it by saying that that is in fact true?
Objection, Your Honor, he's trying to put the burden on the witness.
Given what we're doing, I think that's actually a reasonable question. I'm gonna allow it. So ask him again, because obviously we've interrupted it now, so.
Did you talk to anybody about coming in and offering some supporting testimony for your testimony today?
I didn't know I needed to.
You didn't think it would help your testimony, having somebody else support some of your testimony here that you've been homeless for the past 3 months and living kind of vagrantly in an RV or your truck for some period of time before that?
Didn't know I needed to.
Well, who knows about your living condition like that?
Probably almost anybody that's around me.
Like, what was her name?
People I work with, I mean, exactly, I mean, just like I said, people that's around me. Whether it be people I work with, my ex, nobody told me that I needed anybody here to testify with me. That was nothing was brought up, so how would I know that? Because I mean, I'm sitting here telling the truth, so I didn't know I needed somebody else to back me on that.
So as we're talking about the truth, when did you buy your RV?
Been about 3 years.
From 2024?
It's been probably about 4 years now, yes.
So you recall buying it in 2020?
It was somewhere in that proximity, yes. Because it would have been at tax time, so yes.
So right around the lockdown?
It was right before, it was before the lockdown. Because I remember I had to get a certificate to be able to travel back and forth from work because we were, was considered so you have to work, you can't lock down.
So over the past 4 years, where have you parked your RV? It's a large vehicle.
It's been at 2564 Jackson Road, Griffin, Georgia. I had it parked in High Falls, and there's storage there in High Falls as well that I've used. And I've used a buddy of mine's house as well.
Which buddy?
With Lamar.
So this 2564 Jackson Road, it's a large property, isn't it?
It's two properties, actually. There's two of them linked together. Yes.
About how many acres is it, do you know?
I don't even know how to measure an acre, sir. And I've never asked.
It's next to a lake, isn't it?
No, not a lake on the property, no.
Is it gated at the public roads entrance?
Yes, there's cattle gate.
So when you parked your RV there, did you park it next to the house?
No, it was under our awning.
And when the RV was parked there, were you sleeping in the RV?
Yes.
So you didn't sleep inside 2564 Jackson Road?
No.
So
You're in an RV.
But you are still residing on the property?
When?
At any point from 2020 until now?
Oh, I thought you said now. So no, I'm not. I just told you I was not residing there. Until I was homeless.
Right.
Like 3 months ago, that's what I'm saying.
But at times during, so at what times between 2020 and 2024 were you living in your RV under the awning at 2564 Jackson Road?
I would have to literally go through a calendar and then try to figure all that out, because I couldn't give you an exact date, because then I would be lying, because I don't know, I'm not gonna lie to witness. I'm not gonna say a lie. I couldn't give you an exact date without actually going through a calendar and figuring it all out.
Is that because you lived there in at different periods during that time?
Yes, this was said between there and High Falls, yes.
Was your RV parked at 2564 Jackson Road on June 25th of last year?
June 25th of last year? No, sir.
What about on June 17th of 2023?
June 17th? No, sir.
What kind of RV is it?
It's a bumper pool.
How do you spell that? Do you know?
No, sir.
Can you say it can you say it again slowly?
Bumper pool.
Bumper pole.
Not wasn't a fifth wheel, it was a bumper pool. One that pulled behind like a trailer.
So you pull this around behind your truck?
Yes.
Where is it now?
The RV?
Yes, sir.
I sold it.
When did you sell it?
Probably middle of the year, roughly.
Of last year?
Yes, yes.
Why'd you sell it?
I had no use for it anymore.
You don't have a home though, right?
Understand that, but there's a lot of bad memories there. That's why I got rid of it.
Well, I'm sorry, I'd like to ask, what kind of bad memories of this RV?
I had an ex that was very abusive, and I didn't want it no more, but thank you for digging that in there.
So you've been married before?
Your
on to the
Honor,
next.
objection.
Sustained, move on to the next topic.
You have a cell phone with you today, right?
Yes, sir.
Does your phone bill go to 1244 Lavelle Street?
I paid on the app. I believe that's where it is. If I'm not mistaken, that is where it's registered, yes. Or when I fill out the paperwork at T-Mobile.
So since you were 18, you haven't gotten a new number?
I think back on, I've had the number that I have now for several years. But probably at least 5 or 6.
So when you got a new number, you didn't update your address to where you were living at the time?
Which one is the number you're referring to? Because T-Mobile is the only one I've had. I've had the same number since I've had T-Mobile.
678-933-8017.
That's the same phone number I have now. Yes.
And you say you just pay on the app now?
That's That's what I've always paid it.
And did you mention that some mail goes to LaBelle Street to your grandmother and uncle?
Yes.
What kind of mail is that?
From my understanding, there's past medical bills or any of that stuff.
So sitting here today, you don't have anybody else you can say that you don't live at the Lakewood address. Let me get the address right. 560 Lakewood Drive in Griffin, Georgia.
I don't even know where that address is located, so.
You've lived here your whole life, right?
Yeah. Where? Georgia?
In Griffin?
No.
Where else have you lived?
1244 LaBelle Street. Jonesboro, Georgia.
So I understand. So until you were 18, you were at LaBelle Street. And then you lived at the Forest, the Jackson Road address?
No.
Where did you live before? Like, can you describe to me where you've been?
In Georgia, from 1244 LaBelle Street is where I went to elementary school, or school altogether. My childhood, because my grandparents are in the house. And when I left there, I was married for a brief time. And that was the 338 Hammond Drive. And then I went from there to pretty much the 2564. I was talking about the 2564 Jackson Road.
This is.
Oh, I apologize. There was one other address. I apologize. It was 608 Hood Road, Concord, Georgia.
So you said that you've had this 678 phone number for some time now. I believe it's the same phone number that was on the police report in the accident that's underlying this hearing today. There is a sheriff who entered has an entry of service from last year. Actually, it's the year before that, it was in 2022, stating that he called that number and that he spoke to you about this case. Do you recall that?
No, sir.
Are you saying that the sheriff is lying?
No, I don't. You said, do I recall it? No, I don't recall it.
You don't remember having a conversation with a police officer?
No, I don't remember it.
So
Not that I'm aware of.
that call happened on March 31st of 2022. Where were you living at that time?
Honestly, I don't know at the time.
But you had the same phone number?
Yes.
Were you living at 2564 Jackson Road at the time?
I just told you I don't recall, sir.
Do you recall where you were living in early 2022?
Honestly, no, I don't want to say it. Honestly, because you've got me frustrated, to be honest with you, because I don't. I mean, you're already picking at me.
Take a deep breath.
I'm trying, sorry.
Deep breath. You're doing good. Just deep breaths. Don't argue with him.
I'm not.
Just answer the question.
Yes, sir. But no, I don't recall this time. It would have been most likely the 2564 Jackson Road.
Do you recall if in early 2022 you were living in your RV there?
Yes, it would have been the RV, because I've only lived in the RV at that house are at that property.
And there isn't anybody else in your life who could offer testimony that you weren't living at the 2564 Jackson Road address at the time the police officer called in March of 2022?
Honestly, I don't know. Because the only person that was living with me then, I do not speak to. 2022, I'd have to go back. I may have been at work, for all I know. Depending on what day it was.
And I don't want to frustrate you or anger you too much, but so then it's really just your testimony today that we have then, right?
That's what I'm under the impression it was supposed to be.
We don't have any affidavits that were signed by anybody else with direct personal knowledge about your whereabouts at the time?
I didn't know there was supposed to be. If I'd have known this, I guess I would do it, my homework or whatever you want to call it, but no, I had no knowledge about needing anybody's affidavit. I didn't know anything about this.
Those are my questions.
All right.
Thank you.
You were ready.
No, Your Honor.
You missed it. Thank you. Any additional witnesses to call or present?
Not from the defense, Your Honor.
All right. Any witnesses you wish to call from the?
No, Your Honor.
Thank you. Sorry, I was going to say state, but that's not you. All right. Then any closing argument?
I would just like to point out, Your Honor, that the only affidavit of service in this case that was filed and then had an affidavit of due diligence filed supporting it clearly delineates that a Brandon Virgil Cole was served or purportedly served on August 30th of 2023, and that the separate affidavit of due diligence outlining attempts on Brandon Lee Cole does not result in service, which is clear from the face of those two affidavits, which are filed and labeled accordingly, I'd add.
I did say, do you have any witnesses to present? You said no.
Yeah, no.
Okay, so I just want to make certain I did that, so, because I did the state plaintiff thing. Okay, just have a little moment. All right, closing.
You mean opening?
Sorry.
Did you mean opening?
I'm so sorry. I thought this was closing out this hearing, but you are certainly welcome to present and argue as you see fit. I think I'm mixed up on our procedure here. I thought the question was to determine if he was service or not. Well, that's what I thought. I thought I just gave you a shot, but my question was too narrow. Let me rephrase that. I asked the right question the wrong way. It's your turn.
Yes.
Sorry, I specifically said, do you have any witnesses? What I meant to say is, it's your floor. Mr. Hope nudged me over
Since
here.
I haven't had a chance to look at this, do you mind if I just inspect it for a second?
It's all yours. And again, I apologize for the way I did that, because obviously it gave the impression that I wasn't interested in your side, and I very much am interested in your side.
An affidavit of service is prima facie evidence that service has been effective. That's what Exhibit S in my response has. A duly appointed court process server went out, did his research, has exhaustively exhibited in his affidavits of due diligence on both of the Brandon Coles, and I'll come back to that. But nevertheless, this was the place that was the most likely spot. It was the place that pinged everything right. And given the vagrant lifestyle that we've just learned about, I think all of the yarn on my cork board makes a little bit more sense. With regard to their demonstrative, the top part, I can't speak to any of that. I did not handle the case at that point. I took on this case about a week before it was filed, the second time. So all of the stuff on the bottom, I can answer questions about that. I'm prepared to do so. But on August 30th, we have service. There's an affidavit that says there was service on somebody who identified himself as Bruce Evans, and he said he co-resided with Brandon Cole. Doesn't say that he co-resided with Brandon Virgil Cole. Doesn't say he resided with Brandon Lee Cole. It just says Brandon Cole. The law says that the affidavit of service is prima facie evidence and can be set aside only with clear and convincing evidence. That is the strongest nature that the case can admit. So in this case, I suppose this was the self-serving testimony of Mr. Brandon Lee Cole that we just went through. I think that this court should expect there to be a bit more of an affidavit showing that would prove that he wasn't at these places and that he wasn't living with Bruce Evans at the time Steve Basham subserved him on August 30th of 2023. There's plenty of case law on this. It goes both ways, where you have an affidavit of service and you have somebody trying to set it aside. And those cases, generally speaking, have affidavits that the court can use to decide whether or not the affidavit should be set aside. Generally speaking, we'll give you specific here. In McRae v. White, this is a Georgia appeals court case from 2004. There was unrebutted evidence from direct knowledge and affidavits by other members of the defendant's family and business associates that said the person in that case was not somebody that the defendant knew, and that the defendant didn't live there because he lived somewhere else. Like that makes it clear that I've been barking up the wrong tree, because you have the person hiding in the tree saying one thing, and you have all of his family and friends confirming it. We heard today that all we have to go on is the person sitting up in the tree. There's another case, Moore v. Wilkerson. This is another Georgia Court of Appeals case from 2007. In this one, there were affidavits that the family, neighbors, and employers of the defendant lived all in the same community that he did, and that the process server didn't talk to those people, didn't do any investigation whatsoever into the whereabouts of their target. But that's not the case here. The affidavits and the affidavits of service and the entries of service that I have in this case, which are many, indicate that an officer of the law in March of 2022 spoke to him on the telephone. The only way the police officer would have had that information is from the police report, and that's the same number he has today. So I think he spoke to him.
Hold on just a second. So I found Moore v. Wilkerson, and I have that one as 283 Georgia App 340, but I was not able to find your first case without a citation.
Oh, sure. That is 269 Georgia App 455. And I believe that case is the most on point for this issue. Because in that case, the Georgia Court of Appeals discussed other cases, such as Yella, which is a case that's very similar, in which the defendant submitted affidavits with the motion to dismiss, including a business associate, and that service was made at the daughter's residence and not him. So we had a motion to dismiss filed on the 2nd of August of 2022. And from their point of view at this table, nothing factually has changed, but there was no affidavits filed in that motion. And in their reply to my response, there's even a citation to an affidavit that was not included on there. I don't really know what the point of that was. We still haven't seen an affidavit. Instead, we had in-person testimony from the one person who would disclaim everything that I'm trying to prove. So that's all we have. All we have is self-serving testimony that He wasn't in any of the places where he should have been. He gets mail sent to various different places. I served all those places. I tried them all. They all came up on my searches. And I think what it ultimately comes down to here is a conflation of two troublesome concepts happening at the same time. On the one hand, you have somebody who has a very vagrant lifestyle, who lives in an RV, who goes from place to place, even sleeps at his employer's parking lot. And at the same time, you have this public records issue with a Brandon Lee Cole and a Brandon Virgil Cole who have overlap with some of their contacts. And there has been a lot of importance given to the fact that he was born in 1984? 1980s. He was born in the 1980s, which does not make him a 102-year-old man. Brandon Virgil Cole, as they will tell you, he was born in the 1920s. If he's still kicking around, it's even more surprising that his aunt still is, and his brother still is, and all the other people who knew Brandon Cole when I sent my server over there. They weren't confused. They weren't like, it's the geriatric 100-year-old man over there. They didn't tell anybody that, oh, Brandon Cole is dead. They said, Brandon Cole doesn't live here. They said, I'll forward the information to him. That's not the kind of thing you say to a 100-year-old. Those people need care. If they make it that far, it's amazing. If Brandon Virgil Cole is still around. But there's no affidavit that we have that says that I served Brandon Virgil Cole and not Brandon Cole, but Brandon Lee Cole. I think I mentioned this the last time I was here. I'm a junior, which means that whenever I do things, I get mixed up with my dad all the time. My process servers and my investigators told me that is what was going on here. You have ancient records from a 100-year-old commingling and merging with databases from a younger man who has lots of interactions with the law, who has lots of addresses associated with his name, probably associated with that vagrant lifestyle we learned about today. That means that we don't know where he was. He couldn't tell us where he was. We have not learned exactly where he lived at given times, except for 2018 and up to his marriage, where he was at Hammond. But it sounds like after that, he kind of moves from place to place, which confirms what my process server was telling me, that his license plate would show up in different various places, and by the time he would get over there, it was gone. And whenever it was at a house or a residence, he would knock on the door, try to serve the papers on Brandon Cole, and was told that Brandon Cole doesn't live there. So I think that answers some of the question. But we're looking at a case here with a defendant who's showing up in open court to contest that he doesn't know about this lawsuit, when the record shows, not his testimony, which is now part of the record, but the record up until today shows that he talked to an officer about this case, we talked to his aunt about this case, the sister we tried to serve him at his sister's place, same thing with his brother. The brother said, oh, he's not here, let me give him your card, he'll call you back. That's what the affidavit of Mr. Stonica says. And then we go back there a month later and we find out Brandon Cole moved. I don't know how a 100-year-old moves. I think it's more likely that Brandon Lee Cole was the Brandon Cole I was after. There's been reference again in Ms. Amick's opening about a motion for service by publication. Two things about this. Number one, the case law on this is that a motion for service by publication is necessary under the UM statute. My client does not have UM. So by going through the motion for service by publication, I would not be preserving any right to protect my client's interests. On the other hand, I'm being told by my process servers that they're on the scent, like it's just one house away. It always felt like that. It's like, we're gonna get him soon. We found him over here. Obviously, his house is moving around. That causes this story to happen. Ms. Amick's demonstrative right here does not show how many times I tried to serve him and at how many different places. The number's 27 times. "27 times. We served Jackson Road, 1, 2, 3, 4, 4 different times. We served Lakewood 1, 2, 3, 4, 5, 6 times. And we served every other place, including that Hammond Drive address you referred to earlier, in which case the person who answered there told me in every instance that Brandon Cole doesn't live there. The only 2 places that didn't happen were at Jackson Road and at the place where Mr. Basham perfected service on Bruce Evans. At those locations, there's never answers, there's no answers, until finally I have service on 8/30 of 23. So as a final remark I'd like to make, this is obviously an unusual service case. And my standard up until she filed is reasonable due diligence. There's a reason behind every one of my actions, and there's not delay. Anyone who has experience in trying to serve somebody knows that you don't do it yourself. You can't slap on your Nikes and go beat the pavement and do the job yourself. You have to rely on other people. You have to rely on the conclusions they draw from the information that they get, all at the same time being completely deprived of what the truth may be when the actual defendant is ultimately found. Which means it's a moving target. It means that in January, I'm trying to figure out this, and then in February, it has to pivot because my factual understanding of the circumstances changed. That's not a delay. That's me moving. That's me making reasonable decisions to affect service. So for example, when I tried to serve his sister, I had to issue a check from my office on February 24th of 2023, so we're almost a year ago. When the sheriff got this check, it took him a month to give me back an entry of service. I can't pick up my telephone and personally call the officer, because I don't necessarily know who that is, and ask, why has it been 4 or 5 days? But during the same time period, that's not my only lead that I was chasing. At this time period, there was another license plate that was seen, and I immediately sent the guy over to back to Jackson, where the license, the Jackson Road address we keep talking about, where the license was found. So weeks here and there, that's usually what happens. The longest delay that I have is the one starting on July 1st until their filing of their motion. And to be, quite honest, I had hit every single place on every single database that I could find. And the ones that kept popping up, I hit multiple times. So we were probably going to file a motion for service by publication at around the time that we got the motion to dismiss. And when I had that, I'd read some of these cases before. Like, even if I have an order on service with a motion for service by publication, it means nothing if there's not personal service and we find ourselves in this very same hearing. There's a case where this very same thing happens. That is Griffin v. Stewart, 362 Georgia App 669 from 2022. So it happened last year. In this case, the plaintiff got an order of service from publication, and there was a 5-month period of inactivity after that trying to get personal service, and the defense filed a motion to dismiss, and it worked. It worked. There was no basket I could put the eggs in with that strategy. Besides, I had 30 days to respond, so I just whipped my guy the hard as I could to get back out there and be around, so when the license plate came up again, he could identify the location, serve the papers, so that we could have an issue of service as opposed to non-service. And I'd like to conclude a little bit by talking about a Georgia Supreme Court case from 1953. I know I mentioned that last time. It's an old one. But there's a more recent one from the Georgia Appeals Court from 1981. So the Georgia Supreme Court in Jones v. Jones, 209 GA 861, it says, the law requires service not simply for form or as a snare to trap litigants or to prevent adjudication of a legal controversy, what's happening here, but its sole purpose is to put the defendant on notice that he is being sued and afford him ample opportunity to be heard on any defenses that he may wish to make. I kind of feel like that happened today. And in the appeals court, in Trammell, Trammell v. National Bank of Georgia, this is 159 GA App 850. In this case, it has similar posture to ours. The defendants produced affidavits that the service was insufficient due to the age of the person served. The defense argued that the fact that the Trammells actually had knowledge of the lawsuit and thereby gained actual knowledge of the pendency of the suit, the court said is irrelevant. They said that that is completely wrong. They do not agree. Quote, in cases where actual notice of the suit has been received by defendant, our service law should be liberally construed to effectuate service. I think that's the appropriate move here. I think that the motion to dismiss should be denied. I think that this case should be adjudicated on the merits. It's obvious that both of the parties are now aware of it and in a courtroom ready to go through that. Because, as I mentioned earlier, Ms. Benson has no UM. This is the end of the game for her, because somebody that lives in their car and moves around and lives here and there and can't provide any evidence that any of that is true other than his own testimony, her case has to end. This will be a terminal thing that's outside the statute. I can't dismiss and refile. And it's probably a case that should be tried. I think it should be tried. I think it's in the interest of justice, and that it would be a manifest injustice to cause the case to die right now, when we've heard from the person who is the proper defendant in here today talking about where he has and has not been without a lot of particularity and without any evidence to support it. So for the reasons that I've explained today, I ask you to deny the motion.
All right, thank you. Anything else?
Your Honor, if I may respond briefly, I'll try to be as brief as possible. I don't want to belabor this point, but I do want to point out there's been mention of an affidavit from the initial suit. It's noted on our demonstrative as disputed. And I just want to point out that the only time that sheriff's entry of service actually appears anywhere in the record is as Exhibit A to plaintiff's response to our motion. It was never filed in the original lawsuit. It was never filed as an affidavit in this lawsuit. It's not notarized, I'd note. So I'd just like to point out that and ask the court not to rely on that. Getting back to the larger picture, plaintiff's counsel has spoken at length about the testimony that we heard today. regarding prima facie evidence of service when there's an affidavit of service filed. What the court says is that conflicting affidavits even may be sufficient to dispute return of service. We have provided the sworn testimony of the defendant who, not merely in the form of an affidavit, but plaintiff had an opportunity to cross-examine the sworn testimony. And then I'd go back to the substantial delays in time between service attempts. I don't dispute that there were 27 separate attempts. They were not on 27 separate days. The timeline we have there is accurate. And I've noted there it says attempts. I did not mean to mischaracterize that at all. But 5 days over the course of 324 days that attempts were made on Brandon Lee Cole. There have been a lot of assumptions made about things that aren't in the record, about what individuals who were met by the process server may have said or could have said or might have said if X, Y, or Z were the case. The evidence the court has to rely on is in the affidavits of due diligence that the process server, Mr. Basham, who was appointed in May of 2023, filed. And I think there's a reason that those are clearly delineated by 2 separate names. They were filed with 2 separate names, Brandon Lee Cole and Brandon Virgil Cole. And the affidavit labeled Brandon Virgil Cole is the one that results in the purported service on a Bruce Evans. The affidavit labeled Brandon Lee Cole does not result in service at the end of the due diligence. And I believe there's a reason that the process server drafted those and signed them the way that he did, because he was clearly looking for 2 different individuals. Each affidavit delineates different addresses. There is not any overlap between the addresses on those 2 affidavits that were filed separately. Merely learning of a suit is not the basis for notice, and the plaintiff still has a burden to serve the defendant swiftly after the statute of limitation passes, which it did on October 12th of 2022. This is after the plaintiff already had an original opportunity to attempt to serve the defendant in the first suit, and it's not even clear that any attempts were made in that first suit. So while we do understand that dismissal with prejudice is a severe remedy, is the appropriate remedy in this case, because the plaintiff had ample opportunity to meet her burden of locating the defendant. It is the plaintiff's burden, and the law is clear on that. And the defendant was not located in this case, and public record searches, there are a lot of red herrings in this case that make it perhaps appear more confusing than it is. It's very straightforward. The plaintiff hasn't served the defendant. It has now been over a year since the second complaint was filed and since the statute of limitation expired. And so for those reasons, we ask the court to grant our motion and dismiss the complaint with prejudice.
All right, thank you. Okay. Anything else? From either side?
No, Your Honor.
Anything else?
No, Your Honor.
All right. Y'all have briefed this well, and I appreciate the efforts y'all have put into this hearing today. You've all done a great job. I'm going to take this under advisement. I want to go through the file again. It's obviously a critically important decision, and given the acknowledgement that it would be the second dismissal, it would be the end of the line. So I'm going to slow down a little bit, take a good look at it. No, okay, we don't need proposed orders. So, all right, if you'll leave that, if you don't mind, your poster.
Sure.
How did you make that, on a quick side note? What software program?
We actually used a vendor, and I have the name, Case Imagery is the name of the vendor.
Okay.
Yeah, just on the back
I have
there.
to do chronologies every now and then, and I thought, no sense in recreating them. Do you have an objection with me keeping that? And-
Can I take a picture of
Yeah,
it?
of course.
I have a digital copy that I'm happy to send you.
And that's what I was
Fine,
gonna
that
say.
saves me.
I was gonna have you forward it. Take a picture and email it. I
Yeah.
don't have a preference.
Otherwise I have to email my
Okay.
pictures.
All right, y'all need anything else?
No, sir.
Okay, all right, well, make sure to email him a good digital copy that he can review, and obviously, you know, I'm just using that just because it's here and it's for this case, and if y'all take it back, you're just gonna throw it away. So, all right, that's it then. Y'all have a safe drive back to, it will not take long to get my answer, but it will be about 2 weeks or so. So, all right, y'all have a safe drive back.
Thank you, Your Honor.